thank you all for coming. I really appreciate it. It's lovely to see colleagues and one of my students from my first year teaching here who's now a colleague. So it's a really, really moving occasion. So my presentation on my not at all favorite kind of laws, ag-gag laws. It's maybe for a celebratory occasion, kind of a bummer. They're not very fun. This is based on research that I published a couple of years ago, a paper that I co-wrote with Sam Skinner, who's based in Ontario. And there's a fair bit of emerging good academic writing on ag-gag laws in Canada because they just kind of arrived here fairly recently, and there's constitutional litigation about them. In our paper, we particularly wanted to look at the connection between the weakness of legal protection for animals and the advent of these new ag-gag laws. So we called it Fake Laws, How Ag-gag Undermines the Rule of Law in Canada. And what we meant by fake laws was that we have what look like animal welfare laws on the books that seem as if they should protect the welfare of animals in industry, in the food industry and other industries, but they really don't. And so, well, that's what we meant when we said that they were fake. Ag-gag law, it's a sort of phrase that was popularized around the 2010s when this became a thing in the US, short for agricultural gag. And it means, it can describe a number of different legal provisions. So there's some complication about that because there's different variations in different places. But the overall theme is that they limit and punish the ways that that people talk about what happens in animal agriculture, or more specifically, the ways that they gather the information to enable them to talk about it. So this goes back to the 1990s in the US, but really the 2010s. The original version in the 1990s didn't really do very much, and then these sort of new provisions that created new versions of trespass really kind of started in the 2010s. We did not have this in Canada, so we who are interested in animal law in Canada sat and watched this going on in the US for a while, and then it arrived here, starting in 2019. So there is constitutional litigation in Ontario, a challenge under a number of provisions of the Canadian Charter of Rights and Freedoms to Ontario's brand new law. It's called the Security from Trespass and Protecting Food Safety Act. Sounds nice, right? Also known as Bill 156. And it's being challenged primarily as a violation of the right to freedom of expression and a number of other charter rights as well. So, what is the backstory? Animals in industry are all in private places, indoors most of the time. You can't see what's happening to them most of the time. So the animal movement and the food justice movement have been trying different tactics for many decades to expose and bring public attention to abuses and cruelty to animals. Ag-gag laws are a way of restricting how people can talk about these things or get the information that they need to talk about these things. And I see it as the latest step in a kind of arms race between animal people on the one hand, trying different moves and different tactics, and the industry employing law to restrict what they do or punish what they do on the other. And in the presentation, I will talk about some things that have been exposed by animal activist exposés, which are not nice. And some of the pictures are, I didn't pick the worst ones, but there are some animals that look like they're not having very much fun. So just a little warning about that. In the paper that Sam and I co-wrote, our argument primarily was that there aren't any real laws that regulate how animals are treated in the food industry. And I'll talk about the food industry, but there are other industries that it's the same thing, like fur, like carriage horses. It's kind of all the same deal. If animals are being used for an economic end, they don't have protection. So we do have laws that seem to do that, but there's a number of problems that they have. It's weak legal standards to start off with, loopholes, exemptions that mean if you're engaged in industry and if you're doing what the industry does, it's not illegal, lack of enforcement. Canada has some of the worst animal welfare laws in the world. So an organization called World Animal Protection periodically does a comparative review of animal laws around the world, and we don't do so well. We got a D in 2020. I think the US is also consistently a D, but like they're also terrible. Like that's not who you want to be. European countries tend to be more sort of getting into the Bs. I don't know if there's any A's. The laws are not great for animals generally. So we argued that ag-gag fits into that picture because it makes the situation worse. Most of us don't know that the legal protection for animals is weak. We would like not to think that it is. And by revealing what really happens in industry, animal activists and people in the movement can sort of counter the narrative that comes from industry. And that can be a corrective and can lead to law reform and prosecutions. But if that pipeline of information is cut off, it sort of reinforces the lack of real legal protection. So to return to sort of the backstory and the arms race, if you think back to the 70s, the 80s, those of you who were alive then, those of you who weren't, you may have heard, you might kind of think in your mind of, people who would like break into labs and like release the animals or steal them out of the labs. That was a tactic. It still is, but it was, I would say, doing outlaw stuff, direct illegal action, was something more associated with animal activism in those days, in the 70s and 80s. And it has faded out a bit. I couldn't really tell you exactly why, but I think that there are two kind of contextual factors that contribute to that. One is law, legal backlash. So in the US, they have a statute that was passed in 2006 called the Animal Enterprise Terrorism Act, that treats these sorts of trespasses and break-ins and stuff as, as if you had broken into like a nuclear facility and blown it up or something, and resulting in people serving very harsh, long prison sentences. So it means kind of reevaluating, is this achieving enough to be worth it in terms of the sort of harsh legal consequences? And I think also another contextual factor is that disseminating information got a lot easier. So that became an alternative that is attractive and can work. So there's been a shift to more towards information, to raising public awareness, getting information out to the public. So this quotation is from Justin Marceau, who's an American scholar who's done fantastic work on ag-gag in the States. And he says, we moved from this sort of era of, the outlaw tactics to whistleblower and expose tactics, where words rather than deeds have become the primary form of advocacy for people who seek to expose food justice and animal welfare issues. So, new tactic, new legal response in the arms race. How do you, if you're the industry and people are saying things about your industry and you don't like it and it causes harm to your industry, what can you do to counteract that? Well, the first answer was libel. So probably everyone knows libel laws mean, there can be criminal libel that's prosecuted or suing civilly people for saying negative things about you or about your business that causes you some sort of economic loss. So, trivia question, a little bit of audience participation. Does anyone know what was the longest trial in England in English history? Any guesses? You may be thinking like Dickens, John Nice versus John Nice, 19th century. You'd be in the wrong century if you were. It was a libel case concerning food. It's colloquially known as the McLibel case, McDonald's versus Steele and Morris. It was very long. The court days were 313 days. The whole procedure from when the writs were first served on the defendants was 7 years. The decision is 1,000 pages long. Another piece of trivia that I learned recently, I don't know if anyone has likes English Lit and read Zadie Smith's new book called The Fraud, and it's about a real case that happened in England in the 19th century called the Tichborne case, where a guy pretended to be this like nobleman who had died in a shipwreck, and he like showed up and said, yeah, I'm him, I want his inheritance. And there was a long trial, and it turned out he wasn't. So what happened in McLibel, Helen Steele and David Morris were sort of ragtag environmental activists in the 80s. You can sort of imagine what they would have been like, and they were exactly what you were imagining. So they were distributing a leaflet that had been put out by this outfit called, I think it was called London Greenpeace, but not the Greenpeace that you know. That was critical of McDonald's. So just standing on a street corner, right, there's no Twitter in those days. It's you get your words out by just handing out paper to people, making these various criticisms of McDonald's. So one was that they mistreated workers, that that their packaging was causing pollution, destroying the rainforests, the use of beef was destroying the rainforests, that the food was harmful to people's health, and that they caused cruelty to animals. Of course, McDonald's doesn't have animals, right? It's in the supply chain. So the kind of charge against McDonald's in this leaflet was, you can control what happens in your supply chain. You're buying the products from farms that treat their animals cruelly. One other trivia item for the Anglophiles in the room, they mostly had to represent themselves, Steele and Morris, but they had some pro bono help from one Keir Starmer, who will almost certainly be the next Prime Minister of the UK, although I hope I didn't curse him by saying that. So the trial decision came out in 1997. It's very, very long and very complicated. And there were some appeals, and there was a European Court of Human Rights case that came out of this as well. But as it relates to animals, in English libel law, it is very plaintiff-friendly. It's friendly to McDonald's. If you are claiming that what you are saying is true, truth is a defense, but you have to show that it's true. So they were in the position of having to demonstrate that what they were saying was true. Some of the things that they had said in the leaflet, the judge ruled that McDonald's won and that they were defamatory, such as saying that the food caused heart disease and cancer. But with respect to the treatment of animals, the judge found that McDonald's was culpably responsible for inflicting unnecessary cruelty on the animals, and that those statements were true. So there's quite detailed discussion of the evidence and what the conditions were that the judge found were what an ordinary person would consider to be cruel, such as battery hens being kept in small cages and severe restriction of movement and not being able to express any of their normal behaviors. The same for sows, female pigs, kept in sow stalls, which is, they're just in a cage that is just about the size of the pig's body, and they just can't move around at all. That's in slaughter because the numbers are so high. Chickens are supposed to be stunned before their throats are cut, but it doesn't always happen. There's a small percentage, but a large number because there's just so many of them. Egg-laying chickens, as a routine matter, have calcium deficiency, so that they have bone disease and their legs break easily. Leg injuries in broiler birds, those are there's two different kinds of chickens. There are ones that are bred to lay eggs, and there are ones that are bred to eat the meat. And the meat ones grow incredibly fast, and their bones can't hold them up, so it's very common for them to have broken legs. And gassing male chicks who in the egg industry are useless. So I just want to add the note that all of these things happen in Canada, and they are legal. They are not illegal. They are, I think, by any normal meaning of the word cruel, but they're not prohibited by law, which is the case in the UK and is the case in the US. This is sort of standard. So I spent a while talking about this case, even though, it's a number of years ago, different country. It's not an ag-gag case, but it fits in, to my way of thinking, very well into this sort of story of the back and forth between people trying to raise criticisms and expose information about the industry and sort of responses using the law. And also, it's just a fascinating case because so much of the evidence that the judge discussed never makes it into court because it's not relevant to anything that would sort of get into court. All of those things I just described are legal. So no one would be prosecuted for gassing male chicks or causing hens to live in very tiny cages because there's no offense. It's not prohibited under the law. So it is generally legally irrelevant. And this is discussed at some length in the case as well. Very, I think, uniquely in this context. You don't really see this in other industries. The fact that something is widely done, that it is sort of an accepted practice in the industry, actually makes it legal. And that's written into our provincial animal welfare laws in, I believe, every province in Canada. So David Wolfson, who wrote a great article on this case, pointed out, we have laws that relate to the cruel treatment of animals, but they do not prohibit animals in industry from being treated in a cruel manner. So the judge said there's a difference. There's a difference between cruel as defined under the law, which has a giant loophole for customary practices or common industry practices, and what an ordinary person understands to be cruel. And because it was a libel case, because it was this sort of unique posture, and the question was whether what Steele and Morris were saying was true, the standard was what would an ordinary person think is cruel, rather than what does the law say is cruel. So you might think, well, if animals, chickens, pigs, are being treated in a cruel way, maybe they can't, the person who's causing that can't be prosecuted. But what about the civil law system? Can you, if you see that this is happening, like say you're working in a factory farm, and you see these things happening, and you think this is wrong, this can't be right, this should be stopped. Can you go to court and seek some way to stop it? And I probably should add there as well, there's two categories of problems that happen in this context. There's the things that an ordinary person would say are cruel, but they're not illegal. But also things that would be prohibited by law do happen too. And we've seen that with undercover exposés, where people sort of kick and punch animals, for example. So things that are not approved practices, just sadistic cruelty. And if you saw that happening, if you were working on a farm, what could you do? Could you go to court and say, ask the judge to issue an order saying that they have to stop it? And the answer is no, you cannot. You might not have legal standing, which is, the court recognizes that you're the kind of person who can come to court and talk about this. Because who's being hurt? It's the animals, it's not you. We do have somewhat more flexible rules on legal standing in Canada now, although they're not always applied so flexibly when it comes to animals. And the entity that is being hurt, the animals, they don't have any legal rights. So they have no way to get before the court or to have a representative get to court. There is also a principle that a civil court will not entertain an application for a civil order to prohibit an act that is prohibited by criminal law or that's a penal prohibition. And that principle was applied by the Alberta courts in a very famous case. It's one of our most famous Canadian animal law cases concerning the treatment of Lucy, an elephant who's in the Edmonton Valley Zoo. So some, animal advocates thought that she was being kept in a way that caused her to suffer, and they wanted to get the court to issue an order. There's an Animal Welfare Act in Alberta. They said this is, there's violations of the act going on. We want to do something about it. Can the court sort of just issue a declaration and say this is causing her to suffer? And that was struck out as an abusive process, and it went to the Alberta Court of Appeal, which also upheld this ruling that it was an abusive process, although there is a really cool dissent by one of the judges at the Alberta Court of Appeal who made the point that this means we have this sort of law-free zone, right? There's apparently a law that protects the welfare of Lucy the elephant, but if no one can get to court to enforce it, what does it really mean? So we have these problems with, things that maybe should be prohibited but aren't prohibited by law, lack of mechanism to enforce the law. There is also, when it comes to animals in industry, Lucy the elephant, we can see her. I mean, she's, you can visit and you can see her on TV and stuff. But animals in industry are inside on private property. There is no way that anyone would see that unless they are permitted to enter by the owners. So it's typically workers who see that. There is a lack of oversight. There's no proactive government inspection of farms. So any sort of enforcement of the law is complaint-driven, but where is a complaint going to come from? Right? Who's going to make it? There's just a lack of transparency about what's really happening. The lack of transparency is connected to the weakness and failure of the laws, and is connected to the strong desire of people who are advocating for animals to create transparency by telling people about what's going on. So the McLibel case was unique because it did bring out these facts, and witnesses were on the stand talking about the conditions that animals live in, which normally is not legally relevant. And so it has been described as an own goal by a public relations firm, because McDonald started this. They sued these, ragtag environmental activists, kicked off this enormous long-running trial, ended up, they did win an award against Steele and Morris for the statements that were defamatory, but they never attempted to enforce it because they don't have any money. They're just like hippies. And in the process, managed to put a legal spotlight on these activities that they were responsible for that they probably would have, when in hindsight, preferred not to have had quite as much attention on. In the US, libel laws also have been used in an interesting way in this area when it comes to animals and food. So US libel law is more protective of free speech than UK libel law is. It's not quite as friendly to plaintiffs. So there's a bit more room to say things that people might not like. But there was a wave of these special statutes that were passed, and they seem to have gone away now, I think, because they're kind of unconstitutional, called food disparagement laws or meat libel laws. So there's one particular thing got this special kind of protection that you can't say bad things about our meat. And you may remember or may have heard that Oprah Winfrey got in trouble for that by having someone on her show, and they were talking about hamburgers spreading mad cow disease. And she got sued for libeling the hamburger under Texas's False Disparagement of Perishable Food Products Act of 1995, which I saw described in Texas Monthly as our most embarrassing statute. It probably isn't anymore. So, so libel is a way of responding to criticism, to people saying things about meat production that you don't like. But there's a problem, as both of those examples illustrate. Libel laws are essentially about false statements, so the truth of the statement becomes an issue. If the activists are saying something that isn't false, first of all, you have a legal case with evidence where there's scrutiny on what actually is happening. And secondly, you may end up with a ruling that confirms what is happening, and that is too much risk of an own goal. In the McLibel case, Steele and Morris didn't actually have any, this is one of the many challenges that they faced. They didn't have evidence about what was happening on farms where McDonald's products came from. Those are private businesses. They didn't have any access to them. Most of the evidence came from McDonald's own witnesses, and they were comfortable talking about it because what they were describing was legal and normal. So they didn't really see it as a problem. But that was in the 1990s. Right after that, the technology for getting and spreading information had a revolution. All of us are walking around with powerful video cameras in our pockets. And all of us can be our own publishing house and our own TV station. We can get things out to the world really quickly. So the undercover investigation and expose became the new tactic. Organizations like Mercy for Animals and PETA, and here in Canada, Animal Justice Canada, started doing undercover investigations and exposés. So one of the early famous ones in the US was Betancourt Dairies in Idaho. This was a Mercy for Animals undercover investigation. It was video that was captured by hidden camera and posted on YouTube, and it was like cows being punched and hit with chains and really horrific abuse. These are things that are true. You can't say that a video is libel because it just records what happened. So enter ag-gag laws, which are about punishing and restricting the way that information is obtained. It doesn't make any difference for the purposes of these laws, if you're being prosecuted for violating it, whether the information is true. The truth of the statements is not the issue. These laws are focused on private property. So you can't usually document what's happening on an animal farm without entering onto someone's private property. You usually can't see from the outside. If you've ever driven past barns in the Lower Mainland, they're just barns. You can't see anything on the inside. So a common theme in these laws is trespass, and expanding the definition of what is trespass and increasing the punishments. So the first wave in the US was in the 1990s. So these were laws that made it an offense to enter agricultural facilities without the owner's consent and record or take pictures, or to do this with the intent of committing criminal defamation. So this didn't really do a whole lot because trespass is entering without someone's consent, so it already was illegal. It's just sort of like saying, yeah, we really mean it. This really is illegal, and farms are special. And it didn't result in any recorded convictions. But the innovation came in the 2010s by creating this new kind of trespass. And this doesn't exist in any other context. The idea of entering onto someone's property without their permission being a wrong to that person being trespassed, that is a very traditional and sort of almost sacred part of our law. But this is a new version that involves not telling the truth when you get permission. So you are entering the property with permission, but you misrepresented something or missed out some information in order to get the permission. So Iowa did the first one, and it created this offense called agricultural facility production fraud. And a person would be guilty of this offense if they lied on an employment application with intent to commit an act not authorized by the owner. So it means you're a volunteer for Mercy for Animals, you apply to be, an entry-level worker on a chicken farm, and you don't tell them that you work for Mercy for Animals or that you're planning to bring in a hidden camera. Idaho passed a similar law. A number of U.S. states with strong agriculture industries have passed these. And the Idaho one was a direct response to the Betancourt Dairies investigation. That was struck down as a violation of the First Amendment in 2018. There have been, I think the total now is 6 of these ag-gag laws in the US have been struck down. The issues in terms of sort of restricting speech, I think, are fairly apparent. The term ag-gag, I don't know if Mark Bittman was the first one to come up with this, but he certainly was the one who popularized it. He is a New York Times columnist, writes about food, and is interested in food justice. And he wrote this column in 2011 criticizing this new wave of ag-gag laws for restricting speech and for cutting off information about how food is produced and connecting it to the lack of law enforcement. And as he said, actual laws. There are no laws that protect these animals. In the US, only federal laws governing animal cruelty apply to slaughterhouses. None apply to farms where animals are protected only by state laws. This is also true in Canada. Only provincial law applies to farms. There is some federal regulation of slaughterhouses if they're interprovincial. And all of the provincial laws have the exemption for customary farming activities. So from the 90s until 2019, Canada did not follow suit in adopting these ag-gag statutes. I don't know why. Maybe there was, lawmakers were noticing that they kept getting struck down under the Constitution. Maybe it's just that things followed on a few years behind here. We had undercover exposés. A little bit later, they started making headlines. So a well-known example was the Chilliwack cattle sales story that came out in 2014. This is, I think, still Canada's largest dairy farm. Video was shot by a former employee on behalf of Mercy for Animals and released to CTV. And it was very shocking. It was very upsetting. Cows were being beaten and kicked, and the workers were saying very kind of callous things about them, hoisted up by their necks with chains. These things are illegal, and some of the Chilliwack dairy workers were actually criminally, they were prosecuted and pleaded guilty. So yeah, that is illegal. That you could not do. But no one would know it was happening if there hadn't been an undercover investigation. So along comes our ag-gag statutes. So the first one was Alberta, 2019. The Protecting Law-Abiding Property Owners Amendment Act, trespass. So this amended the Trespass Act to create an expanded definition of trespass. Ontario passed in 2020 an act to protect Ontario's farms and farm animals from trespassers and other forms of interference and to prevent contamination of Ontario's food supply. PEI amended statutes to create an ag-gag style prohibition. Manitoba, at the federal level, a statute was just passed around the end of last year that is focused on contamination. So those are the two theories of why we need this: protecting private property and protecting the food supply from contamination. So I will talk a little bit about just one of them, the Ontario one, Bill 156, because that is the subject of a constitutional challenge. There may be others in the future. It's a complex piece of legislation, so I won't talk about everything because it would get very boring, but some of the highlights. To me, the biggest highlight is that it creates this definition that is beautifully Orwellian of something called an animal protection zone. And an animal protection zone is various areas on farms and slaughterhouses, so nice form of protection. And some of the offenses that are created by this statute they only exist in an animal protection zone. So it is a unique kind of, newfangled trespass that things that wouldn't be trespass any other place, they are in an animal protection zone. So it's an offense to enter these places without the consent of the owner. All right, so far, pretty conventional. But if you did get consent, but you obtained it under false pretenses, then it's not consent. And the regulations go into some details about what that means. So it includes giving false statements about your employment qualifications. So if you applied for an entry-level job in a chicken farm, and you have, a master's degree, and you don't tell them, that's lying about your qualifications, and it's false pretenses. There are some exemptions for journalists and whistleblowers in this statute and the regulations, and this seems to be kind of driven by awareness that there may be constitutional issues about this, because the Act obviously restricts the ability of journalists and whistleblowers to talk about what happens on farms. So it may have been an effort to charter-proof it, but the exemptions are very limited, and they're kind of, they don't match how these investigations really happen, probably deliberately. So a journalist, this doesn't apply. You would not be chargeable with this new offense of trespass if you're a journalist, but only if you meet a number of conditions. One of them is the journalist doesn't cause or contribute to causing harm to a farm animal. So if you are doing an undercover investigation, you're trying to gather this information, get a story out to the world about what's happening, as posing as an employee, getting a job as an employee, in a place where the whole business of it is harming animals, this is pretty much impossible to do. Like, what are you going to do while the people are gassing male chicks? Just stand aside and say, oh, I don't do that. Like, you would pretty much, they would know that you were an undercover investigator pretty quickly. And then the other one is the journalist essentially has to work for the conventional news media, which again is not how this happens. Volunteers for sort of activist organizations go in, gather the information, and then work with the media to get the information to them. They're not, there has never been one of these investigations done by a sort of salaried employee of a traditional news organization. So and also the landscape of news is so different from what this contemplates. There's a lot of independent investigation and journalism going on that wouldn't be covered by this exemption. There's also an exception for whistleblowers. So I think of journalists as the people who go in because they want to find out the information. Whistleblower, I think of as someone who already works there, so you didn't get your job by lying about it, but you see things that disturb you and that you think the world should know about, and then you record it or gather information about it and get it out to the world. So there is an exemption for whistleblowers, but there's a number of limitations, including you only get this exemption if you report the abuse immediately, right? So again, it's a constant thing. And if you see some harm happening to a chicken and you don't immediately go and report it, you lose the exemption. So there's no ability to do sort of ongoing gathering of information. And the whistleblower didn't cause or contribute to the disclosed harm. So same problem. As a worker in these facilities, that's kind of your job. Another thing in Bill 156, and this is a Canadian innovation. So this is not something that was in the US ag-gag statutes. And now they've picked it up from us, and Iowa's adopted this one. An offense to interfere or interact with a farm animal in or on an animal protection zone. So this is aimed at, there's a movement called the Save Movement who protest outside of slaughterhouses, essentially. And their tactic is bearing witness. It's sort of standing and observing and being present while animals are brought in on trucks to the slaughterhouses. They do quite commonly do things like spray water on animals, on pigs on trucks when it's a hot day, give them water to drink, touch them. Pigs are really friendly, and generally domesticated animals are really friendly. So if you get near them, they want to sort of like nuzzle you and be affectionate. So even if the people don't touch the animals touch the people. Someone was unsuccessfully prosecuted in Ontario for giving water to a pig on a hot day, who was a Safe Movement person, Anita Kreintz. That wasn't illegal, but now it is. In Ontario, it is. So any of these actions, touching a pig on a truck, giving the pig water, would be a crime now under Ontario law. And I actually can't remember if it's included in the Alberta one. It might be. So the constitutional case, the challenge focuses on the ag-gag statute as a restriction on speech. The government's defense of it focuses on this law as a protection of private property and of the integrity and sort of cleanliness of the food system. So they have a small bit of a point in that these actions are, entering onto someone's private property, and there's no constitutional right to use somebody else's private property to make your point or to say your piece or get your speech out. But that only makes sense if you look at it outside of the network of everything that affects animals. They are on private property, they are hidden. The speech that is created by these investigations and exposés would be impossible without the ability to gather the information. And these are very unusual provisions. It creates a form of protection that doesn't exist for any other industry. There is no special trespass statute that protects other industries from people exposing what is going on, like in their factories or something like that. So Justin Marceau makes that connection to free speech by saying, cutting off the right to access and document misdeeds in the production of food cuts off a critical supply of speech that is critical of the agricultural industry. And Joanne MacArthur, who is a photojournalist, and her organization, We Animals, many of the photos that I have comes from her organization. So she puts it as ag-gag sort of criminalizes the wrong thing. It turns the attention towards the journalists and activists who are trying to expose animal cruelty and away from the cruelty itself. And that reinforces Canadian misconceptions that cruel farm practices occur elsewhere and not here. They occur everywhere. Jody Lazar is a constitutional scholar at Dalhousie, and she's written 2 long analyses of the constitutional issues here. She argues that ag-gag laws violate the right to freedom of expression, but they're sort of like extra violations of the freedom of expression because they hit at exactly the kind of speech that the Charter is meant to protect. First of all, truth, like getting facts out, and secondly, talking about issues that are controversial, are political, that people want to know about, right? Like, I mean, in a way we don't want to know, but what happens to our food when it's being produced is of great interest to the public. And these facts are a sort of counter-narrative to what the industry would like people to think. We have slightly different constitutional law from the US, so these laws have not fared well under the First Amendment in the US. In Canada, there is a possibility that a law can be justified, even if it is a restriction on freedom of speech, if it's a reasonable limit that is demonstrably justified in a free and democratic society. And the Ontario government, of course, argued that it was, as a protection of private property and the and protecting the food supply from contamination. The problem is it's hard to match up these laws with the justification. So there's never been a documented example of biosecurity disease being introduced into a facility by activists doing undercover investigations. If anything, it's probably protective of that because in addition to exposing animal cruelty, this can expose, unsanitary practices. Trespass, of course, is illegal. It's already illegal. Private property is already protected. What does it do to expand trespass so that now it's also trespass if you lie about your employment qualifications? It doesn't seem to do anything that is about protecting private property more. It really seems to be targeted at stopping undercover investigations, preventing investigators from getting in. In one of the US cases that struck down an ag-gag law, the court pointed out that there was no evidence that the prohibitions are actually necessary to protect perceived harms to property and biosecurity. So we're right at the beginning of the story in Canada, a little further along in the US. We don't know whether the Ontario court will strike down the Ontario law. I would put money on it that it will. I've watched some of the argument, which was on Zoom, and I don't know, I wouldn't have wanted to be on the government side of that one. It was a pretty tough argument. But whatever happens, it's very likely it will be appealed. And there are other ag-gag statutes in other provinces, so there may also be constitutional challenges in those provinces. There may be more ag-gag laws. So in BC, we do not have one, but there was a bill that was introduced in 2019, and that might come back. In addition to the constitutional problems, there's evidence from the US that these actually aren't great for industry because it sort of gives this impression, more than an impression, that there's something to hide, and it tends to erode public trust in the agricultural industry. So agricultural industry people don't necessarily want it anymore in the US. In some legislatures, they have actually spoken against it. So that dynamic might happen here. But meanwhile, something to watch is perhaps the next stage in the arms race. So We Animals, Mercy for Animals, maybe other organizations are using drones to collect footage. This is a shot from a mega dairy in Arizona. There's about 10,000 cattle there, so that's it's not old McDonald's farm anymore. It's pretty stunning. So you can get this image by flying a drone over it. That's probably not trespass, and I'm sure my discussant is an expert in property law. He may have something interesting to say about this. As drones, we use drones for more things, there's probably going to be some interesting issues about the airspace over people's land. Basically, the law is if you're far up enough above it, you're not trespassing. So maybe there'll be a legal response to that too. Maybe there'll be a tightening up or expansion of the definition of trespass to shut that one down as well. So I at least will watch with interest to see what happens next. Thank you all so much for your attention. It's an important topic and I really appreciate your coming to listen.